Oh, Robert. Okay, we're going to do Schiff now. We're going to do Schiff because I want to clip this and snip this because it's a story. People need to hear this. Despite all of the, not vitriol, what's the word? Righteous indignation. I loathe Schiff. I don't loathe him as much as Trudeau. I loathe him. He's a liar. He's a bad, bad man, to quote Jerry Seinfeld. What's that show called? Seinfeld. But notwithstanding that, it's not the case that because I politically loathe a human, that I'm prepared to tolerate what might be unjustifiable political retribution. I forget who the Florida senator is, or the Florida person. I forget who it is now, who made this censure bill. To motion to censure and to fine Adam Schiff $16 million for the false statements that he put out as relates to Trump collusion. He's seen clear evidence of Russia-Trump collusion. Before we even get into this, I want you to refresh everybody's memory as to why it was so insidiously dishonest what Adam Schiff was doing, because there was confidentiality surrounding the hearings. He was stating outright lies, knowing that nobody could contradict him without breaching the confidentiality rules as relates to the hearings, something along those lines. Bottom line, they put in this motion to censure to fine Schiff $16 million, the rationale being it's roughly half of the price of the Mueller investigation. And it's not clear that it's constitutional. It's not clear that it's justifiable. Thomas Massie, who he has yet to say something that I vehemently disagree with. And so when he takes a position that's contrary to what you want him to take, you have to listen hard. He says we can't support this. 20 Republicans didn't support it. It's not constitutional. It violates basic rules of due process, unjust fines, whatever. And Robert, I think you agree with that. Let us know your thoughts on this. But first, before we get into that, am I not wrong? I'm right about this. Schiff, when he was lying, knew that there was no one who knew that could come out and say why Schiff was lying because of the confidentiality provisions in effect.
Yeah, I mean, the historical context for this is that Schiff, as head of the House Intelligence Committee, spent $32 million of taxpayer money to smear the president, using his access to classified information and the limited access to that classified information amongst the public and the press to lie about Trump repeatedly about what that evidence showed, knowing that people could not on the committee rebut him without disclosing classified information. This is another example of the misuse and abuse of classified information. Like the movie Sneakers, there are too many secrets. And that's the point of Julian Assange. That's the problem behind the Trump indictment. This effort to elevate a secret part of government that can lie to us without consequence by them getting to control and monopolize access to secrets. So in response to that waste of $32 million, and the problem was because it was congressional money, because he did it in the course of his congressional duties, the speech and debate clause prohibits anybody from suing him, including Trump, for Schiff's lies and libels, for his misappropriation of these funds for politicized purposes that misled the American people and misappropriated effectively these funds to the defamatory detriment of President Trump. So the question was, what's the remedy? The remedy proposed by this Congresswoman, Luna, I think, if I recall right, had a three-part resolution. One was to censure him, to condemn him, and then to fine him. The grounds were, quote, conduct that misleads the American people that was, quote, not befitting an elected member, was the factual foundation for the assertion of this congressional power to not only censure, but to issue a fine, quote, fine him in the amount of $16 million. That amount is basically half of the amount that the committee spent on these smear campaigns. Now, the constitutional issues implicated by this is first, Article 1, Congress has only given, the House of Representatives has only given legislative power. It's not given executive power. It's not given adjudicatory power, at least not in most instances. There is a limited exception. It's given legislative power to write its own rules governing itself. It's also given adjudicatory power and enforcement executive agency power for the purpose of, quote, punishing its members for disorderly conduct. However, the remedy of expulsion cannot be utilized unless there's a 2/3 vote in support of it. The only other provision that provides for any kind of punishment are, quote, penalties for non-attendance. And that's it. So that's what the Constitution has to say about what power Congress has outside of the legislative context. Now, the only times this has been litigated in the courts is in the case of Adam Clayton Powell and in a case called Kilbourne. For the most part, the speech and debate clause, Thomas Massie is currently litigating the issue of fines by Nancy Pelosi in the mask mandate context, and it's going before the D.C. Court of Appeals as we speak because the district court wouldn't allow the case to proceed, largely on grounds that the speech and debate clause immunizes members of Congress from any kind of suit as long as what they're doing is part of their duties. And the question became, was what Pelosi did part of her duties? In the Adam Clayton Powell case, he gets elected to Congress. He's very controversial. Congress refuses first to seat him, and then when they do seat him, they don't really seat him. They claim to expel him, but what they really did is exclude him. They refused to seat him. He sued. The U.S. Supreme Court said that the courts do have jurisdiction over when things like this take place about seating members of Congress. And they said the qualification clause is the full limit of what Congress can do. This is pertinent to the president, by the way. What it means is if you meet the qualifications clause, nothing else matters. They can't say that because you've been indicted. They can't say you didn't file your tax returns. They can't add qualifications to the Constitution. And they said while the Congress could have expelled Powell, it couldn't exclude Powell because he was duly elected. Now, the Kilbourne case has been misinterpreted. In Kilbourne, they went after people connected to John Jay. Not John Jay, the justice, but a future Jay. But basically, they tried to imprison a private citizen for non-participation in discovery concerning hearings that Congress was conducting. And what the Supreme Court, in passing, the Supreme Court referenced that Congress might have the power to even imprison its own members. But it actually doesn't really say that. It's addressing whether or not it has the imprison. It's like, we're not dealing with that issue. We're dealing with this other issue. And what it said was, quote, Congress could not, quote, adjudge a man guilty of a crime and inflict the punishment because that would be conceded by all thinking men to be unauthorized by anything in the Constitution. That's what the Kilbourne case actually said. Now, it's very rarely litigated for the reasons noted. This power is very rarely utilized by members of Congress. There have been state legislatures that have done this as well. It rarely reaches the courts, and it usually gets resolved or dismissed before it gets to any high level of adjudication. So it's mostly an unresolved issue judicially. So you have the precedent set by the legislature, but those precedents are all over the place. I would say that trying to find someone is both rare and has always, in the case of the House and Senate, been restitutionary. The argument here is that this is restitutionary because of the amount of money spent by the committee, but that's not how it's been used in the past. So this was an attempt to punish Schiff in ways that Congress had never done before. They had done small fines on a restitutionary individual basis. In other words, that congressman got the benefit of, say, $2,500 he didn't deserve, so he was ordered to put $2,500 back in the kitty. Not a case of, well, your committee spent a bunch of money. We don't like that. We're going to make you pay that back. That's a very different kind of claim. The other potential constitutional issues are, first is the First Amendment, which is this punishment for speech, and does it apply to Congress? Second, the Fifth Amendment, is there a cognizable property interest that's at issue? There would be if there's a personal fine, and that gives rise to due process of law. Was due process afforded here? Under the Eighth Amendment prohibits excessive fines of any kind, period. That means the fine has to be proportional. The Eighth Amendment's where cruel and unusual punishments prohibition exists. It's where the excessive bail provision exists. It's all about limiting the state's power to punish. And the Supreme Court has interpreted that as about proportionality. The 27th Amendment, which says you can't change congressional salaries until there's another election. And the only enforcement mechanism for this would be docking a salary. So my view is, Thomas Massie said, this is an excessive fine. Thomas Massie is disputing Congress's ability to find members of Congress, period. He has filed suit against Nancy Pelosi over the mask mandates and the mask fines that he was issued on this grounds. So it'd be hypocritical for him to turn around and say it's okay to fine Schiff. So Massey's position is not only consistent, it is, in my opinion, constitutionally consistent. Because what the Constitution says is that their only executive power Congress has is, quote, it may punish members for disorderly conduct, but if it's expulsion, it requires 2/3 remedy. To me, that methods of punishment is intended to deal with people like the Tennessee legislative case, where they are usurping the actual hall of debate and totally derailing it with a mass raid of people. That's, to me, it doesn't say Congress can punish members, period. It says Congress can punish members for disorderly conduct. I would note that Congress itself has said this can't apply to prior congressional sessions, that this can't apply to outside of Congress conduct. And this is why I opposed any punishment on Marjorie Taylor Greene back in 2021, which was they're trying to punish her for non-congressional conduct, private conduct, and pre-congressional session conduct. Here, they're trying to punish Schiff for conduct that occurred in a prior congressional session. Congress has never done that, to my knowledge, ever before. I'm not in favor of that either. I think the Congress's power should be read as being very limited. Stop disorderly conduct on the floor of the House and the Senate. That's it. Now, you can have some ethics rules that are part of their legislative authority. You can have penalties for non-attendance, and you might be able to have some degree of ethics enforcement, but that can't include anything that constitutes criminal punishment, like a fine does. To me, restitutionary awards that are proportionate can be legitimate constitutionally, but once it goes past that into punishment, it's impermissible. The issues you have with Schiff is, to me, Article 1 doesn't authorize their punishment because it's retrospective. It's for things that happened to a prior congressional session, and it's not proportionate in the way in which they're putting it out as. Second, I think it does violate the First Amendment. It's really punishing him for his legislative activities and speech, and kind of says so. I mean, again, the resolution itself says conduct that misleads the American people. That's not what the Constitution says you can punish for. It says you can punish for disorderly conduct, not any form of misleading the American people. There's First Amendment issues. There's Fifth Amendment due process issues. There's Eighth Amendment excessive fine issues. There's 27th Amendment attempts to dock fee issues. That this is not the effective, proper way. And by the way, Congress has previously recognized these precedents. 1799, the Lyon case, 1858, the Madison case, 1876, the King and Shoemaker cases. They've recognized they're not supposed to be punishing for things that didn't happen in the current congressional session anyway. So when you look at also, you should respect elections. And by punishing for conduct after people have reelected someone, I have a problem with. That's really ignoring it. And so then you're finding a property without apparent, to me, due process in this kind. If you're talking about $16 million fine, you should have a trial by jury.
Well, no, Luna's argument was that the fine could have been paid from committee funds, in any event. So it wouldn't have been a personal fine. It would have been, I don't know, whatever.
But the resolution said fine Adam Schiff $16 million. So now she's apparently going back and rewriting that provision to resubmit the censure, because there is clearly grounds to censure him. I would still have problems with that because it's a prior congressional session, and there's been an intervening election. And so I'm not, I think what Schiff did was horrendous, but I think their power to punish him is not there constitutionally.
Well, except, I mean, the Steele Manning rebuttal to that would be, there was an intervening election, but then we had the Durham report, which revealed the degree after the election to which Schiff
and that argument's been tendered before, but to my knowledge, they still haven't punished someone for pre-election conduct, even when their awareness of its illicit nature was not disclosed until after the election.
Now, you said exclusion, but not. So you said expulsion, but not exclusion.
Kick him off committees, deny him assignments, deny him all of his privileges in the House, other than voting. That's where I think is a permissible remedy. But otherwise, I don't think it's constitutional the way they're currently going about it. I think Steve Bannon's wrong. All these people calling for these folks to be primaried are wrong. Thomas Massey is right. And again, he's been consistent on this across the board. And I'm not going to reverse my position from Marjorie Taylor Greene, where I condemn that punitive action is unconstitutional and say, well, I hate Schiff, so I'm going to change and pretend the Constitution doesn't apply anymore.
And the speech and debate immunity, again, nobody should like the idea of broadening disorderly conduct to words. Why wouldn't he still benefit from that speech and debate immunity even against the censure?
Oh, he would, because that applies to judicial action and executive action, not other legislative branch action.
Okay.
So
right.
Now, I mean, I think there's, they can also they can look at expulsion and some other remedies. But again, I think the best remedy is just strip him of any power in this committee, publicize the bad acts of what he did in the past, and prospectively limit his power and authority. And it shouldn't be limited to him. The other Democrats on that committee went along with it.
Mm-hmm.
They should all be stripped. If you went along with the nonsense of Russiagate in the House, they should strip all of them of committee powers.
And beyond that, of not contradicting and not pushing back on Schiff when he had clear and convincing evidence of Russia-Trump collusion. It was a bold-faced lie. Like, we now know it. All right, good. So in as much as we all hate Adam Schiff, or some of us hate Adam Schiff, I think Democrats hate Adam. I don't think anybody likes Adam Schiff.
He's probably the next senator from California. He's used this to his benefit. This has not hurt him politically in the Democratic Party, unfortunately, in California. It's helped him.